Hello everyone, this is Crypto BitLaw back with another blockchain legal brief, and today we're going to be covering a Texas lawsuit that was recently filed in a federal court in Texas wherein a Bored Ape Yacht Club owner is suing OpenSea over a security exploit in the platform that resulted in his Bored Ape NFT being compromised. So before we dive in, as always, if you enjoy this content, please hit that like button and subscribe to our channel. That would really help us out going forward. And if you'd like, you can also follow us on Twitter. Our handle is @CryptoBitLaw on Twitter. So with that said, let's dive on in and parse this out. So here we could see Decrypt reports that a Bored Ape owner files a $1 million lawsuit against OpenSea over a, quote, stolen NFT. They say a Texas man is suing OpenSea over an exploit that saw high-value NFTs, including his Bored Ape, sold for a fraction of their cost. And pretty much the brief of it is that Timothy McKimmy, he wants his Bored Ape NFT back and or damages of more than $1 million. And his lawsuit may just be the first one over an exploit involving, quote, inactive listings on OpenSea. It states, a Texas man who unwittingly sold his Bored Ape NFT for 0.01 ETH, or the equivalent of around $26, is suing OpenSea, alleging the platform knew about a bug that allowed hackers to buy NFTs for far below market price. On a side note, regarding that bug, I'm going to link this article down in the description below that does a deeper dive into what the bug is, and pretty much the long and the short of it can be summed up here. It states that if NFT holders transfer their NFTs from a main wallet to a secondary one and back to the main wallet, they can virtually, on the front end at least, delist their item from OpenSea. But this transfer method does not actually appear to cancel previous listings on the blockchain's backend, leaving NFTs vulnerable to this exploit. So it has to deal with the transfer feature and how it's implemented in OpenSea. But if you want to learn more about it, you can check out this article, and it's going to be linked down in the description below. But continuing on, the article states that in a complaint filed in Texas federal court, Timothy McKimmy claims he is the rightful owner of Bored Ape number 3475, one of a set of 10,000 highly coveted primate NFTs known as the Bored Ape Yacht Club. He claims that he did not list his Bored Ape for sale and that the NFT was, quote, stolen, and that the buyer promptly resold it for 99 ETH, or roughly around $250,000 at today's prices. According to McKimmy, the ape in question is in the top 14th percentile when it comes to rarity, and is significantly more rare than the Bored Ape NFT Justin Bieber recently purchased for $1.3 million. He is seeking, quote, the return of the Bored Ape and or damages over $1 million. McKimmy, whose LinkedIn profile lists him as the CEO of a Texas iron ore firm, claims that OpenSea knew about the bug, which was widely reported in the media, but refused to halt trading in the interest of profits. Quote, instead of shutting down its platform to address and rectify these securities issues, defendant continued to operate. Defendant risked the security of its users, NFTs, and digital vaults to continue collecting 2.5% of every transaction uninterrupted. The complaint alleges in accusing OpenSea of negligence and breach of contract. McKimmy further alleges that he repeatedly tried to resolve the issue with OpenSea. The company, he says, told him it is, quote, actively investigating the incident, but has failed to do anything more. He is far from the only one in this situation. In January, OpenSea issued roughly $1.8 million in refunds to users affected by the exploit, though it remains unclear how exactly the company is handling reimbursements and determining refund amounts. McKimmy's complaint cites chatter in NFT forums that alleges OpenSea has been approaching other victims of the bug and offering them the, quote, floor price, which is the lowest priced asset in any given NFT collection, even if their particular NFT is worth more, and only so long as they sign a non-disclosure agreement. OpenSea did not immediately reply to a request for comment about McKimmy's allegation. All right, so just based off of what we have here, I think we could tell that OpenSea, yes, they were aware of this, and it appears like they're actually going to try to settle out of court with a lot of the affected users. So we can see here they're offering people that were affected by this the, quote, floor price for their NFTs and then getting them to sign an NDA. So in a sense, that's kind of a settlement. We don't really know what the terms of this NDA is and whether or not they're waiving any and all claims against OpenSea by signing this thing. But just kind of what I can tell based on what's going on here, that appears what OpenSea is doing. I feel like they're trying to go directly to these affected individuals and get them to settle out of court so they don't have to go through all the headache of the legal fees and litigation in order to actually get some sort of settlement or resolution to these issues. Next up, I think it's worthwhile to consider the terms of service that OpenSea gets every user to agree to before actually using their platform. And in terms of terms and conditions that I've seen, this one's pretty rock solid. I mean, they've had their lawyers really really throw in the kitchen sink when it comes to this. This is pretty good stuff right here. And it definitely favors OpenSea. So scrolling down here, and by the way, this is going to be linked down in the description below if you'd like to see it. But some points of note right here. They have the intellectual property rights. Yeah, that's not as important as some of the other ones right here. Okay, indemnification. So this is a pretty big section. By using their platform, you're agreeing to hold OpenSea harmless as a result of certain actions and claims, unforeseen and foreseen, so on and so forth. So this is pretty big right here, this indemnification section, section 10. Number 12, the assumption of risk. I noticed some interesting parts right here. There are risks associated with using internet and blockchain products, hardware and software risks, risk of malicious software introduction. You accept or acknowledge that OpenSea will not be responsible for any communication failures, disruptions, errors, distortions, delays you may experience based on the blockchain. And then there's some other good stuff in there. Limitation of liability. You're pretty much agreeing not to hold them liable. And that's a pretty pretty rock solid clause right there. And then here's another big one. Dispute resolution and arbitration. I know that a lot of major big corporations, they include an arbitration clause in their terms and conditions. And the reason for that is they want to keep a lot of these claims and disputes out of the court system for the sole purpose of, well, I guess it's multifaceted. They don't want all of their dirty laundry aired in public, in a public forum, which would be the courts. I mean, if you have a sealed, if the case is sealed, then they could keep all of the matters and the pleadings private. But if it's unsealed, then everything's public and people could just kind of go in and see what's going on. And a lot of information that OpenSea would otherwise like to keep private, that would be all out in the open. And so A, they do it for privacy reasons, and B, more often than not, arbitration tends to favor businesses and larger corporations, because when you are in the court system as opposed to arbitration, you have an option for a jury trial, and more likely than not, a jury of your peers is going to be more favorable, or is going to favor a plaintiff that looks and acts and pretty much feels like them, as opposed to a big corporation who is sometimes seen as the enemy of the everyman, right? So a corporation would have a better crack at a case in arbitration, right? And so they include this arbitration clause, and I've seen it a lot when a plaintiff files a lawsuit against a company that has an arbitration clause that the plaintiff agreed to, the defendant company, can actually kick it back out of the court system and send it right into arbitration. And then that's where it stops in terms of playing out in court. See, here we see it again. Waiver of a jury trial. You and OpenSea hereby waive any constitutional and statutory rights to sue in court and have a trial in front of a judge or a jury. There it is, right there. And the governing law and venue. Even though they filed in Texas, the plaintiff did, based on this choice of law clause, OpenSea wants all of the disputes to be governed by the laws of the state of New York, right? So, I mean, based on what I've seen here, this terms of service agreement is pretty heavily favored in terms of OpenSea. And I feel like the plaintiff is going to have a really tough time getting through this. This is, I guess, the first layer of defense that OpenSea has up. And, even though they filed their complaint, the plaintiff did, here, turning over here, we could see this is the docket. And this is going to be linked down below in the description. And here's the case, the caption, McKimmy versus OpenSea, and the case number. It's filed in the Southern District of Texas. And here is a copy of the actual complaint. We can see here. Southern District of Texas in Houston. So this is kind of based out of Houston, I would imagine. And it names the parties. You could do a deeper dive. This is actually one of the smaller complaints that I've seen. It's only about 5 or 6 pages, and I like that. I like that when they keep it nice and short and to the point. Based on everything I see here, I think first and foremost, the plaintiff is going to have a hard time actually having this play out in court. But what I think is going to happen, I think that OpenSea will settle with this plaintiff based on the fact that they have been offering floor price level settlements to other affected individuals that were affected by this quote bug. I feel like they are going to try to offer some sort of settlement to this plaintiff, right? But it's just a matter of coming to that right number. So I don't know what the floor price of Bored Apes is right now, but it seems that this guy, the plaintiff, McKimmy, is claiming that his Bored Ape was rare and it was worth more than the floor price. So it's just a matter of coming to that number that is that perfect sweet spot for both of the parties to want to accept this and just move on. So I think what I'm going to do is do a review and analysis of this complaint in a separate video and do a little more in-depth analysis and then tie it back to these terms and conditions and the exploit and just kind of wrap it up in a more in-depth package for everyone. But I just wanted to get this information out there. This is pretty new, breaking stuff. I know that this lawsuit was filed. When was this filed? Let's take a look. February 18th. So it's only a few days old, right? So I guess with that said, I hope you guys enjoyed this content. If you did, please hit that like button and subscribe to our channel. Let us know what you think down in the comments below, and let us know any other topics you'd like us to cover. We really like your feedback. And with that said, thanks again for watching, and we will see you all in the next video. Thanks again.